Okay, so basically the biggest theme, and I apologize to anyone who's done criminology before, you could probably go and listen to Victor, but this is like criminology 101 done with a debating framework. And I absolutely love this stuff. It is my undying passion in the world, talking about evil people. That's why I like MAD so much. So, a lot of the debates that you're going to have are going to be about discretion. That is the execution of discretion within the criminal justice system. Who should do it, how they should do it, what types of things should inform them in doing it, what they should take into account. So it's worthwhile considering where the discretion points occur in the criminal justice system. Some are obvious, right? Like clearly a jury has discretion. Clearly a judge has discretion in assigning a sentence. But more importantly, the police have a great deal of discretion, and they're actually really important in the way in which the justice system operates. So, if we focus on these sort of points in the criminal justice system and look at who has the discretion in each one of them. So who has the discretion over whether or not to arrest? Cool. Let's get some participatory inclusion happening here. So the police largely control whether or not they're going to arrest somebody. What informs whether or not they arrest them? Pardon? Sorry, speak up. Shemang? Yeah. So generally, police choose whether or not to arrest somebody based upon the same way that you or I would choose to whether or not to arrest somebody. Whether or not they're serious, whether or not they're busy, whether or not they give a shit, and generally whether or not they have other priorities on their account will determine whether or not a police officer is likely to arrest somebody. Who decides whether or not to charge somebody? Yeah, to some extent the prosecutor chooses. But in 99% of cases, who will decide whether or not to charge? Yeah, it will be up to the same police officer who decided whether or not to arrest, whether or not to lay charges. But that decision might be a little bit different. Some of the reasons why somebody might arrest somebody could differ quite largely from the reason why somebody would want to formalize that charge process. So a lot of the time the cops just want to stop something happening or use arrest as a threat, but don't actually want to go through the paperwork that's involved in actually charging somebody. Let's push through this a little bit quicker. So a prosecutor, which prosecutor in our system has a decision about whether or not to commence proceedings? Anyone? Cool. For indictable offences, that decision is largely made by the Director of Public Prosecutions. If it's not an indictable offence, so if it's a less serious offence, who makes the decision? Largely the police, again. You might be sensing a trend here that the police, in getting you into court, have a huge amount of unchecked discretion about whether or not you ever get in front of a decision-making body. The way in which those proceedings are conducted can be determined by the offence that you've had, by the aggressiveness of the prosecutor or the aggressiveness of the police person going about it, and largely to do with your own choice about whether or not you want to have that matter tried in a higher court, whether or not you want to plead guilty, whether or not in a civil proceeding, which is not really relevant here, but to some extent you have a choice about whether or not you use a jury in a criminal matter. All of those are decisions that are going to affect the dynamic of the trial in which you have. Who decides whether or not you're guilty or innocent? Sorry, guilty or not guilty in a criminal trial? Cool. Sometimes it's the judge. When a judge is making that decision, what are they more commonly likely to be known as? Yeah, cool. And if a magistrate or judge isn't deciding guilt or not guilt, who will make that decision? Jury. Cool. Sentencing? Does the judge receive any consultation or advice on sentencing? How does the judge work out what the sentence is? Yeah, they can consult precedent, legislation, but largely it's up to them, right? And we're going to go into sentencing in a lot of depth because that's the area that I'm most interested in. And this is the one that's often forgotten, and that's the parole board. So these are just public servants. These are people employed by the executive at the discretion of the executive government who determine whether or not somebody is allowed out on parole. So never underestimate the role of parole and the role of parole officers in determining whether or not somebody's sentence is really the 30 years that the judge handed down or the 18 years non-parole period that the judge set as well. So, in just about every type of area of matter that you're going to do in debating, this accountability and efficiency crap is going to come into it. Okay? But in criminal justice debates, it actually diversifies a little bit more. And you can often have debates about whether or not the public or us should have a democratic say in the way the criminal justice system operates, whether or not people with expertise or experts should govern the way in which it operates. And that normally plays out in a debate about elections versus government appointments, is the most common way in which that's going to play out. There's also a debate about sentencing policy and about the things that should be taken into account and the principles and aims behind a sentencing policy, and in particular, sanctions that might be handed out in that sentencing procedure and which ones are most appropriate for getting those outcomes. There's also a lot of debates about whether or not the victim's interests should be prioritised or considered at all, or about whether or not society's interests more broadly should be what drives us in prosecuting or not prosecuting. And the last sort of one that I'm going to mention, which is not a debate but is a comment that I want to make, is about fear and the role that plays in perceptions of crime and justice. So let's jump right into some of these. So we've already spoken about the role that the police have in holding discretion. The other thing that is worth noting about police is that they're gatekeepers. So that is, the prosecutor never gets a go at a defendant. The judge never gets an opportunity to sentence. The jury never gets an opportunity to consider that crime if the police don't arrest. And in a lot of cases, if the police don't choose to bring that matter to court. So the police discretion is crucially important to understanding who is likely to come before the cops. So there are three ideas behind policing that are up there, and I don't have time to go into them into a lot of detail, but let me explain them. The first one is community policing. That's essentially based on the notion that police by consent. So that is, everyone's happy to have the cops around because they trust those cops, and the cops are going to make their lives safer. So there is a mutually beneficial relationship between the public and the police, and there is a degree of information sharing between them. Right? That's a pretty rosy, idealistic sort of picture, and it's what you want to work for, because it means that the public are more likely to give information to the police, they're more likely to trust those police officers, they're more likely to respect them, and those police officers are going to have the greatest ability to engage with the public on that. Who can see a problem with community policing compared to zero-tolerance policing, which I think is self-explanatory? Who can see a problem that arises between community policing and zero-tolerance policing? Cool. In what sense? Yeah, okay, so anywhere in which you are maximizing discretion at the point of the police decision, rather than in zero-tolerance policing, in limiting their discretion by legislation or regulations or oversight that say you must always arrest this type of person doing this type of act or this type of crime in this type of way, the police then have that choice about how they engage with the community and the relationship they're going to have with it. And problems with corruption and accountability are the biggest problems in places where community policing have occurred. This third one here is a sort of in and out, in vogue type of policing theory, and that's problem-orientated policing. Once again, to some extent self-explanatory. This is where police, instead of just targeting offenders or trying to stop crime, they actually go and look at things that are causing that crime. So who can think of some things that police might target or police might do in the course of looking at problem-orientated policing, as distinct from just arresting bad guys? Yep.
Looking at why someone might commit a certain crime, like either their background or their experience that has drugs or something like that, dealing with the drug issue rather than just something else.
Yeah, absolutely. So what are some manifestations of how you might go about dealing with drugs rather than just arresting the people who either deal or consume those drugs? Who's ever been on a bus late at night? Yep. Right. Okay. Who's ever been on a bus without people on that bus? Has anyone ever noticed that there's a lot of blue light on buses? Do you know why that is? It makes it so you can't see the veins. Right? Has anyone ever noticed why at lots of railway stations there's lots of light about and they're deliberately well lit? It's because that's types of problem-orientated policing whereby the police not only are there physically in attendance but have set up systems and have thought about how in which they can manage the environment or manage individual people and getting them to stop committing crimes in the first place. Another big program that's pretty common in Australia is police in schools, which means police officers go to schools and attempt to build up relationships with those cops in that environment. Because they recognize that a lot of crime occurs and a lot of deviance occurs in young people because they want to rebel and break out and because they think like they can challenge the police and it's an adversarial gang, us versus them dynamic. But police have been finding that when they go to schools early and have discussions with people in late primary, early secondary education, they can build up positive relationships and have a dynamic where kids don't see police officers as those with the guns and batons, but see them with a loud, clear voice that it can explain things to them like nice and clearly in ways in which they can comprehend. And that breaks down the likelihood of people being antagonistic towards the police. So, we can all sort of envision the difference between over-policing and under-policing. So that's where police either arrest disproportionately more people for some types of crimes and arrest other types of crimes or other types of people or in other types of circumstances less. Who can think of examples of things that are over-policed in our society? Cool. Probably speeding, yeah? I would say that a higher proportion of people who speed are caught than just about most crimes. What else is over-policed? I really feel like it's not, Finn. Yeah. Cool. Yeah, sure. That's probably not the most explicit example I've ever thought of, but absolutely over-policing that. You were on the right track before with the D word, but what were you going to say? Yep, probably over-policed. Let's think of some more serious crimes. Cool. Drug offences are referred to as being over-policed. So that is, police actively target drugs disproportionate to the number of drug takers and the effect they're having on society. What are crimes that are under-policed? To some extent, assault might be rape. Rape is highly under-policed. It's getting better, but it is still comparatively under-policed. Well, yep, that's sort of difficult to prove would be one reason why the police might not push forward with a charge or might not make an arrest. But the difficult to prove sort of would come more into the trial process. But you're absolutely right that police anticipate the likelihood of a conviction and that might lead them not to arrest. What's another reason why rape might be under-policed? Of reporting. So that is, the matter doesn't even get to the police such that it can be policed. So we're sort of building up a little bit of a database here of reasons why things might be policed or might make it to the court and might not be. Sometimes they could just be to do with the explicit biases of the police. So that is, for a long time they didn't consider domestic violence a real crime. And they considered drug addicts to be immoral and against the social fabric of society. And so they would target those crimes or target particular types of incivility. Or in America, there was a great degree of prosecution and to some say persecution against types of minor social offences, things like being publicly drunk amongst minorities. So sometimes it can be biases of the police. Other times it can be more subtle. It can be things about the victim or about the nature of the crime or the nature of the way in which that crime is often done that might affect whether or not the police get it. Let me put this question to you. A cop goes into a McDonald's late at night in the CBD and the McDonald's hands them a cheeseburger and says, "Thanks for hanging out." Corruption? Yeah, well, that's the distinction, right? When we come to prosecuting corruption, it's important to realize that the definition of corruption, if you want to hold it to a pure sense, is anyone accepting money or reward or some sort of benefit in exchange for either doing their job that they otherwise should have had to do, or to providing special treatment or restricting adverse treatment of a particular group. So that could be as much as not going to KFC, but instead going back to McDonald's because you know you're going to get a free cheeseburger. That is a form of corruption. And the point being is it is almost impossible to restrict because the types of people you would then empower to stop that corruption, what's the problem with that? Who do you empower to stop corruption amongst the police? Who do we empower in Victoria? Yep. So the OPP would prosecute them, but who's the investigative body? Spit it out. I know you've got it. Come on. Yeah. So the Police Integrity Commission, or not commission rather, the Office of Police Integrity is part of the police force. Who's above them? Yeah. There's a police ombudsman. There's an ethical standards bureau. But all of these are largely going to be police officers or former police officers, right? At which point, how do you keep each chain in this level accountable? And how do you enable them to be at every McDonald's on every Saturday night to make sure coppers aren't taking cheeseburgers? So the problem is that if you can't detect when someone is getting a cheeseburger, how are you going to detect when they're taking money for that particular crime? The same regulatory problems that exist for cheeseburgers exist for drug crime, and exist for shakedowns, and exist for all other types of corruption by police officers. Does everyone sort of see why that cheeseburger example and the problem in trying to prosecute someone who did that is a reason why all corruption within the police force is hard to do? So in debates, never underplay the effect of a particular policy's enforceability in terms of whether or not it's likely to be under-policed or over-policed because of biases or some sort of inherent non-pejorative reason, and the effect that police corruption or the attitudes of police towards particular offences might have on the way in which they have their discretion. We're going to look at some of the other parts of the discretionary chain now, but the debates that happen about them all come down to this sort of question between, do we elect people, that is, should the public have a say in deciding who they are, or should they be appointed by government? So all of these debates have the same sort of thing. So we're going to talk about electing prosecutors, electing judges, electing all sorts of people. So you want to look at the faults of elections. Who knows some basic faults of elections? Cool. They're definitely populist. What ways are they populist, Sam?
They cater to the needs of the people, very important.
Cool. And what sort of things resonate in elections? Why? Cool. It's simple, right? It is really simple to say, let's be tough on crime. Let's be aggressive towards bad things, right? Like that is truistic and populist by its very definition. So things that are simple resonate in elections because people have a short attention span. What's another dynamic of elections that might affect the extent to which they were beneficial or represent a real choice? Yeah, Finn? Yeah, cool. Funding. Accessibility of participation within those elections is going to be to some extent determined by your ability to make a bit of money and communicate ideas to the populace. The other thing that's worth noting is that rarely are there elections with more than 2 or 3 people in them. So your ability to access real choice and make a meaningful distinction between a range of policy options is quite limited in an election. They're often rare and they're often fought on lots of different issues, and it's hard for smaller issues to get the attention in those elections. Cool. Then you can question philosophically whether or not you think the public should have a say in the justice system. And we're going to look at this more detail when we go through each of the particular areas that the public might want to say in. But there is a principled decision to be made about whether or not the public should have a role in determining what outcomes or how the justice system should operate, or whether or not that should be something entirely non-populist and entirely decided by the government. So you need to make arguments either side for that, and those arguments will become clear as we go forward. There's also probably going to be a debate about the role of victims, and we'll talk about that more specifically. So, what are public prosecutors called in America? Who's watched Law and Order?
District attorneys.
Yeah, district attorneys. And how do they get their jobs in most states in America? Correct. Good try there, Lindsay. Keep it up. So, largely they're elected. They're elected in really bitter, partisan elections that are often held at the same time as other general elections within those states. And that's massively problematic for the ways and types of crimes that they focus on. If you were a prosecutor in a southern state in America, would you run on a platform of prosecuting white-collar crime? Or would you run on a platform of making sure those dirty blacks don't take drugs on your street? Which one is going to resonate with the community? Cool. So, there's a question about whether or not the public should keep prosecutors accountable or whether or not the government should keep prosecutors accountable. Keeping in mind that governments are, of course, held accountable by the public at some stage, but less directly, right? And rarely does an appointment of a director of public prosecutions affect whether or not a state government in Victoria gets in or doesn't get in, although it nearly did or nearly could have in Victoria lately. Then you want to have a debate about whether or not performance is going to be affected by one or another. Are you more likely to get a better prosecutor just in terms of good lawyering skills through appointing one or through having an election? So which process of discovering who's going to be a better public prosecutor lends itself to either side of getting a good lawyer? And I don't really know what that third one is. Cool. So In some really bizarre states in America, like even more bizarre than electing your district attorneys, they elect their judges. In fact, they elect their public prosecutors and their judges. So the whole thing is democracy on crack. So who can think of some problems with electing judges? Cool. Yeah. So they're going to be populist again. Yep. Cool. Objective about the facts and issues brought before them. If you're a politician, how do you find out what people think on an issue? Yeah, cool. How do you ask them? Cool. You either ask them in an election where they are presented with a choice, or you poll them, right? Well, do we really want judges in a particular case taking polls on what people think? Cool. So we might question whether or not judges are really best placed as individuals with their qualifications to assess what the public wants. So even if we accepted that the public should have a say, are judges in a place to gauge what the public wants? And that could be a particularly problematic discussion for judges to have. And that's actually a little bit different to politicians. Broadly, politicians can outline a platform. They can say, in my next term, I'm going to introduce the carbon tax, maybe, who knows? And I'm going to introduce this policy, I'm going to apologize to the stolen generation, they're going to sign the Kyoto Protocol, done. All concrete things that I can see if they do or they don't. If I'm a judge and I'm running for election, I have no freaking idea what cases are going to come before me, what the particulars of that case will be, how they'll be argued. So it's next to impossible to run on a clear, consistent platform. And if you do run on one, it's more than likely going to result in some pretty shitty judge decisions, right? So that is a dynamic in which the judges are either incapable of making predictions or incapable of assessing what the public actually wants. Cool. I'm going to give you a second to sort of jot down those things about juries because they're actually broadly pretty boring. But the idea being that juries are this fundamental clash between public participation and the role of the state in appointing a competent arbitrator of the decision. So, it's worth noting that there are two types of things that come into consideration before a court. Questions of fact and questions of law. Who looks after which? Cool. So, juries don't actually decide laws in particular circumstances, generally. There are some exceptions to that, but they're not worth noting. And judges are the ones that sort of put the law together and explain it to juries, and then juries sort of go, were the facts as the judge say they are, and if not, then we should convict, and if they were, then we should find them not guilty. And that's more or less the role of juries. So don't go out and say that juries decide everything in the decision, and that juries can just walk in and basically toss a coin and decide, right? They're highly informed and highly determined by the information. I can send these slides to you. They'll be up there if you want to get more of them down. Cool, my favorite part. So, judges decide criminal sanctions. They're influenced by legislation largely and to some extent precedent. But rarely is a case ever similar enough when it comes to sentencing for judges to rely on precedent. Who's got some ideas about why that might be so? So compared to a criminal trial where you might have precedent governing whether or not somebody was guilty, why would precedent be harder to rely upon in sentencing cases? Cool. Yeah, so sentencing is actually far more holistic in the things that it considers. Compared to the rules of evidence and procedure that exist in the trial phase, sentencing actually encompasses just about everything you could possibly consider about a person. And the law can really just say you're either allowed to consider that or you're not allowed to consider that. So, who can tell me the the aspirations of criminal sanctions as per the Sentencing Act, Victoria 1991? Nope, they call it punishment. No. So, Dr. P, we've got rehabilitation, deterrence, punishment, denounce, Protection. Cool. They're the aspirations. I'm going to put it to you that they only really have two aims or two purposes. To reduce crime and to be fair. Okay? So when you think about it, if you put those things and consider what they're really about, they're actually trying to do the same thing. So let's look. Which of those aims or aspirations fit into the reducing crime, and which ones fit into the being fair? Cool, but I think that what you're really looking for there is deterrence. And what you've highlighted is that denunciation is a shitty aim, and we're not even going to talk about it. It doesn't mean anything. But good, deterrence reduces crime. What are the two types of deterrence you can have? Cool, for non-law students? Cool, so the logic being, you show somebody a negative consequence of their action, they're unlikely to do it again. If you show the public at large a negative consequence of a particular action, they're unlikely to do it again. Cool. Rehabilitation also goes there, and to some extent, protection also goes there. It's a bit of a blunt instrument in reducing crime, right? Like, we're going to lock this dickhead up and he's not going to be able to commit any more crime. Not very subtle. And really, the only one that goes into fair is punishment. And like, maybe, if you believe in denunciation, you can put it there. So, I'm going to say that those aims actually set themselves up to fail. You actually can't do those things. And judges have invented a cool little word for getting around the fact that they're going to fail all the time. It's called intuitive synthesis, which basically means we've got no fucking idea, right? And they go through and they say, we are going to try and be fair, but also reduce crime. But nobody really knows which of those is more important or less important. So a judge says, a fair sentence is going to see you go to jail for 5 years. But I know that if I send you to jail 5 years, you're going to spend 5 years of abusive, crime-fueled, drug-fueled, like violent experiences that are going to come out there with you being the best criminal you've ever been at the end of those 5 years. So in actual fact, it won't reduce crime at all. And the judge says, well, hold on a second. Do I have to be fair? Or do I have to send that person in a way in which is going to most reduce their crime? And you can actually see that those things are regularly going to butt heads together, right? It is very difficult to rehabilitate somebody within a prison environment. It's also very difficult to deter somebody within a prison, to deter somebody without sending them to prison or without punishing them in some way. So that inherent clash between whether or not we should be fair or whether or not we should give the sentence that most is likely to deliver less crime in our society means that judges are often torn between those two things. So who knows the types of thing that judges use in working out what a fair sentence is? Like, if we were a judge playing here now, what are some of the things you'd want to know in working out whether or not the sentence you were considering was fair? Cool. So let's call that degree of mental health, because if they were truly incapacitated, assumedly they would be found not guilty. But I hear your point, right? Like the degree of malice or culpability in the person's mind. Cool. H, yep. Yep. Cool. So any pressures that might have existed, the quality of their upbringing, all of these things could either aggravate the crime or mitigate it. So aggravate, make it worse, mitigate, make it less serious. So as a judge, you've got to say, I am going to think of all the things that aggravate this crime and all the things that mitigate them, invent a value for each of those things, weigh it up on my imaginary scales, work out the value of that crime, then I'm going to think about all the sanctions I could possibly give, try and anticipate how bad they'd be, while trying to work out whether or not I should be considering how bad they'd be for me, for that offender, or for the average reasonable person, and somehow invent a value of each year in prison, or each dollar of a fine, and then come back to the value of the crime that I'd previously imagined and try and weigh them up. Unsurprisingly, this leads to problems, right? Because there are so many factors that have so many different values that are highly subjective about both the crime and the sanction that you're trying to match up to that crime. So this leads to a huge problem of consistency. Because when you're empowering a subjective judge to make moral calculations about the importance or lack of importance of particular factors, or the severity or otherwise of a particular sanction, judges are going to make those calculations differently every time. And there's going to be so many different things that go into making that decision that it's going to be really difficult for anyone on the outside of that judge's brain to follow what's been going on or to understand the reasons behind that decision. So, it's going to be fundamentally difficult to come up with a consistently fair message and also reduce crime. So then they have an inherent clash within those aims between protecting people in the short term and protecting people in the long term from crime, or reducing crime short term, long term. Who can sort of flesh that out for me? Why might there be a clash between those aims that we've already said aim to reduce crime in the short term and the long term? Yeah?
Because most criminals get out, so obviously getting off the street is a way to crime that come out with more harm.
Yeah, cool. Liz, what were you going to say? Yeah, so it's really a question about whether or not you want a criminal to come out least likely to be a criminal, and how long you need to put them away in order to protect society from the immediate likelihood of reoffending. But at the same time, painted over that is the fact that most criminals who come before a court probably won't commit crime the next day but for going to prison, right? Like most people, to some extent, are deterred by the process of going to court, right? But their likelihood of being deterred meaningfully in the long term is dependent upon probably the severity of the sanction, and the severity of the sanction will probably impact their likelihood of rehabilitating or their likelihood of treating that seriously. So you can see here that there's a fundamental clash between giving somebody a light sentence and facilitating their rehabilitation, but risking the public safety in the short term from that person either reoffending because you haven't made a clear deterrent, or reoffending because you haven't separated them from society or the influences that led them to commit crime, and the long term in best facilitating that person leaving prison or ending their sanction period least likely to commit crime. So there's a fundamental clash there. In assessing the fairness of a particular sentence, do you want a judge who sees crimes like that every single day? They see fucked up shit before their courtroom, they think that the world is crazy, they see all the bad things that happen in our society. Should they be the people making the decision about how serious something is? Or should it be the middle-aged, sewing, never gets out lady who sits around and frets about the burglar who's going to jump through a window next? Whose perspective, obviously they are extremes, whose perspective do we value more in ascertaining the seriousness of a crime? Yeah, at the moment we do. Is that a good or a bad thing, do you think? It's a fundamental, irresolvable philosophical clash between people who think crimes should be judged proportionate to other crimes that exist. So someone who commits an aggravated robbery shouldn't receive a really harsh sanction just because the little old lady thinks that every single aggravated assault is bad, even though compared to all the other crime that occurs, that wasn't that serious. Or whether or not we want jaded judges making moral calculations about crimes when really they don't know how bad those crimes are to the majority of people. There's no way to get around that. You've got to have one or the other. One perspective has got to be more valuable than the other, and there really is no objective way to end that dispute. And if anyone does, I'd love to hear it, because it would fix this in my head for me. So, the Sentencing Council of Victoria. And that council seeks to do a whole lot of research about the effect of sentences and community perceptions of them. One of the best things they do is they go to schools and they do this program called You Be the Judge, where they tell you the facts of the case and the kids try and decide what sanction they'd give, and then they sort of compare that to what the actual judge gave and they step them through the process. I guess that's seemingly valuable. I think that it would be really interesting if we let juries set criminal sanctions. That's why I set it as a topic for Mad Mini Grand Final, and I thought it was an excellent debate. So the question really comes down to whether or not the public are more or less likely to give harsher sentences than judges. In the same way as juries agree on the remedies in civil matters. So juries are given the discretion to set the remedies in civil matters, and one juror probably says, I want the remedy to be 100 grand, the other one says, no, I want it to be 500 grand, they probably split the difference most of the time. Yeah, cool. So that would be a problem, right? You would have to tender evidence trying to prove the seriousness or otherwise. Although, assumedly, you probably still tender that evidence to try and persuade the judge. You just present it in a different way, probably. Yep.
It would be very hard in cases that have particular emotional significance and also like where there's a lot of public interest, like Darcy Freeman or Lindsay Chamberlain, I know that's so long ago, or Clark Larson case, something like that, where there's so much like emotional
Yeah.
involvement in it because there's going to be like angry moms on that jury, so there's going to be like issues basically. That would be completely insane.
It brings us back to whether or not that emotional perspective of mothers or just of anyone who can't imagine the murdering of their child is the perspective that you want, or a judge who can rationally, having been quite worldly and seen this all before, put that case in perspective. So like that would be one of the considerations that you'd have to have in that debate about whether or not, because like I hear you on why that would be risky to have emotion guide it, but I also am quite sympathetic to the view that says those are the types of things that should influence the way in which we morally judge crimes. One of the other interesting things to note is that invariably, when civilians in the public at large are given information about crimes and asked what the sanction is, they give less serious sanctions than judges. So of people that have been surveyed and given a blurb about a particular crime, they actually end up giving lighter sentences than judges. Yet every survey that's ever been done, from the Australian Institute of Criminology right down to the punter at the Herald Sun, have found that people want harsher sentences. We're going to look at some stats later on about why that might be. But the notion that when given more information, and when those mothers actually are forced to sit there for weeks and listen to all of the aggravating or mitigating factors that existed in Farquharson's case, the study hasn't been on that specific matter, but you would probably find that people would be at least less severe than they had been on hearing the case on face value. Okay, so that's worth considering. I think it's an interesting debate about getting the public more on board. Cool, so it's the exact opposite, right? So it's the exact limitation of discretion that would say, well, I lie, it's not the exact opposite, but it would be a case in which the legislature sets minimum sanctions, right, in the same way as they set maximum sanctions. Tried in a lot of places in America. It's tried to some extent with 3 strikes policies in the Northern Territory. So for a long time, if you were sent to prison for the 3rd time, it would be for the 3rd offense, you would be sent to prison automatically. And in a lot of states in America, if you get convicted of your 3rd felony, you get a life sentence. So they are the most common manifestations of what's known as mandatory minimums. And that would essentially say that we should determine the sanction based upon the crime. And we should say certain crimes should always receive this sanction, and it should be set out by the legislature who decides that. To some extent, you could also include characteristics about the offender, but it would become very difficult to set out in a charter a long list of things that should affect or not affect, but not afford any discretion to the judge. Yeah, cool. So suspended sentences were recently or about to recently be abolished in Victoria. So that was essentially where the judge could hand down a prison sentence and suspend it for a period of time. So say, you've got a 3-year prison sentence, but you don't have to serve it so long as, I like you for the next 3 years, basically. So at any point, that prison sentence become unsuspended. And that could be indefinitely, or it could be for a set time frame. I don't totally understand why that's any different to a good behaviour bond. And I think that that's the realization that Ari came to before he wrote the recommendation that said that they should be abolished, right? In the actual fact that suspended sentences are just a really dumb way of selling good behaviour bonds to the public. And so I'm a big fan of suspended sentences. I think it's a great piece of specific deterrence that says that if you reoffend, you will get the contribution from that crime and from the one you've already committed is probably a pretty good way of deterring those individuals from committing those crimes. I think saying that you deserve to go to jail, but you're not going to go to jail is a pretty shitty way of communicating that to the public. So suspended sentences are, in principle, a good idea because they allow people to use that threat of jail to get those people back on track, but it's just not a very great way of saying it to the public. Cool. So I'll tie it into this. Why are victims important in debates? Often it's like, we should care about the victim. And the other side says, no, 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 no. Crimes are crimes against the state. The victim doesn't get a role in that. Victims are petty and revengeful, and we really shouldn't allow them to get their way if it comes into conflict with these other aims. Right? Let me tell you 3 reasons that you can use for why victims are important in debates. A concept called double victimization, not to be confused with repeat victimization. Repeat victimization is where somebody suffers or becomes the victim of lots of crimes, right? So they keep being the victim of assault, or they are the victim of assault and then the victim of domestic violence, right? Double victimization occurs where they become the victim of a crime, and then in the course of dealing with that crime, either through the criminal justice system or not necessarily through the criminal justice system, they incur more suffering or more harm as a result of that process. So who can think of some things about the criminal justice system that might end up causing more harm to victims? Cool. What specifically about cross-examination? Flesh that out.
Say, for rape victims having to describe to their cousins go through the actual event.
Yeah, cool. Or even just sitting in the same room looking at that person.
And also accusations of, say, like, accusations that it's your fault, that dignity is good. Lawyers across the trying to make legal leverage you have as if, like, the crime was done on your fault.
No doubt this makes up a lot of lawyers' ethics classes, trying to work out the extent to which you should assist a client you know to be a rapist in attempting to try and get them off by traumatizing a victim. It would be a very difficult position to be in, obviously for the victim, but probably too for the counsellor. It's worth noting that it is actually now against the rules of evidence to ask about a rape victim's previous sexual history. So you're not allowed to ask those questions in Victoria anymore. But that in no way could stop you from insinuating that something about their conduct led to the rape or implied consent. And that, I'm inclined to think that that question too has been banned, but I'm not entirely sure. But things like that are great examples of ways in which you could subtly get around that ban on evidence. So it is just the explicit rule that you can't do that. There have been a couple of steps to enable that process to be limited. One of those is putting up screens in the courtroom. That can take 2 forms. One, computer screens that allow people to testify from outside of the room. Others are literal screens that are put up like you might see in hospitals sometimes to separate the accused from the victim. I have a little bit of problem with the latter there because I think it seriously implies that the person is guilty. And it probably prejudges the whole process a little bit more. I think that using video testimony is probably more desirable. There's probably a debate to be had about that too, although it's quite small. So the process, more importantly, if I tie this back into sanctions, this is perhaps where denunciation could be considered to be important. If you were the victim of what you saw as a serious crime, and you were told that the defendant would receive a fair sentence for what they'd done, they'd receive just punishment, and then the outcome of that process was they got a sentence that you think manifestly fails to meet the seriousness of the crime, how would that make you feel about how the state perceived your victimization and how the state perceived the harm that had occurred to you? So if you were the victim, and this is a real case, of a man who's so high on marijuana and so drunk, stumbles into your house and out of his mind rapes you, but walks out and leaves the second you wake up and tell him to go away. That man received a wholly suspended sentence. But, a plethora of what might be perceived as good reasons. But if you were the victim in that scenario and you got told by the court and by the state that what happened to you did not warrant that person going to jail, that would make you feel terribly vulnerable and terribly like the state wasn't sticking up for you and was in fact on the defendant's side. That doesn't mean that we should punish people according to victims' rights. To me, that means we should stop telling victims that the outcome is likely to be fair. Because every time we go into that process saying this is going to result in just punishment, we are only setting ourselves up for disappointment because it will probably be sacrificed in order for other aims that are less to do with that particular victim. But it's worth noting that the outcome of trials can manifestly affect that victim's perception of that crime and their mental health in general. One of the most obvious effects of this is people's willingness to report crimes. So if you were trying to get crimes like rape that are chronically underreported to increase, one of the primary ways you might go about that is by showing rape victims that courts take this matter seriously and that the state cares and wants to prosecute this matter. And the message you send when the state doesn't hand out severe sentences, or when the state doesn't take your side or doesn't consider your interests or doesn't protect you in the process, is that it's not worth reporting or that it's quite risky to report. And that can have big impacts, especially on sexual assault crimes being reported to police. You want to be careful suggesting that vigilantism is going to occur if bad sentences are given or if the public's views aren't taken into account. It's probably pretty rare that law-abiding citizens will go out and do something against people. In that sense, commit a crime against those people. But be aware of more subtle vigilantism in the forms of ostracization or rejection of people that come out of prison on face value. So people who responded in a survey and said they trusted the courts to give adequate sentences were 3 times more likely than those who didn't to hire somebody in their place of business who had previously been convicted. So there is a strong correlation between people accepting sentences given by courts and them trusting people who'd been released at the end of that sentence. That makes a big impact upon the likelihood and successfulness of your rehabilitation. So think of vigilantism less about pitchforks, more about pink slips. Cool. So this all ties in what I've just been saying about victims and participation, all those things, into a debate that happens commonly about compelling certain classes of offenders to go through with prosecutions. Sometimes it's done, this house would require this house would proceed with prosecutions in domestic abuse cases without the consent of the victims. Or, change that crime to rape or change that crime to any sort of serious case. So, what are some of the good reasons why a victim might not choose to go through with a prosecution or might not choose to report a crime against them? And what are some of the bad reasons? Cool. So why might that lead them to not report? So they're worried about it escalating or retribution from the offender? Yeah, I reckon that probably makes up close to 90% of them. What are some other reasons? So would you class that as a good or legitimate reason or as a bad reason to go forward? I think I'm inclined to think that there are 2 conceptualizations of that. One is that it's bad in that people aren't sticking up for themselves and aren't breaking that cycle. The other is that it's a perfectly legitimate reason. The criminal justice system manifestly fails to successfully prosecute domestic abuse cases, manifestly fails to build up enough evidence or to get convictions for them. I think that under the status quo, it would be perfectly legitimate for somebody to say, I would rather take my chances in an abusive household than to go through the trauma and the risk of reporting, having a failed prosecution, and ending up suffering the consequences from my partner. It's not to say that one person should do one or another, but there are legitimate rational reasons why a victim might not want to report. And you want to try and characterize them as rational if you're on the side of the debate that wants to say that they don't have to go forward. And as the other side, you want to say the state has a role in overriding that choice in certain classes of circumstances. Okay. Broadly, you can tie in all of the stuff we've just said about victims to this debate specifically. Do you have anything to add?
I was going to say, you can also flip that in regards to domestic abuse and suggest that people might be also afraid that the sanction placed upon the offender might be too harsh and they don't want to dob someone in who they actually care about and then for that person to get a punishment which they perceive to be much greater than what the crime actually was. So you can potentially look at that.
Yeah. One of the most bizarre phenomenons in the criminal justice system is often the people most dissatisfied with harsh sentences are victims. And one of the reasons why people commonly cite, not just for domestic violence, against going through the process, is that they don't trust that process to uphold what they want out of it. So some people want offenders to go to prison. They want them to be locked away and throw the key away. they actually represent a much smaller majority than you would expect. There are a significant chunk of victims who want restorative justice, or who want a form of mediation, or want a form of continued relationship with the offender in question. And their skepticism about the ability of the criminal justice system to provide that leads them to either not report it or to not continue with the prosecution when they see it getting out of hand. That begs the question, what comes first? Do we reform the justice system such that those people feel more like coming forward? Or do we need them to come forward in order to be able to reform the justice system? It is a regrettable chicken and the egg scenario that leads to many people suffering a lot. And that's a shame. Especially corporate fraud. Okay, there's a lot of words up there. So, amongst people who claim that the most important source of information about the criminal justice system is radio and television, you can see the stats up there, but they overwhelmingly want harsher sentences more than people who don't. What does that tell you about those mediums and the way in which those people are consuming information? Cool. So, what are we, like, let's flesh that out a bit.
So, particularly the tabloid media and the programs on TV, they want to create an environment where people are come up and after about something, and therefore they make it sound like everyone was asking parts of it before. They make up, not make up statistics, but they make it sound a lot worse than it is, and it's not actually reflective of what it is.
What's the incentive for tabloid media to do that? Cool. Why does it sell? Surely a more sophisticated sentence, the story explaining the different reasons and the competing side might make people be more thoughtful or reread the article and therefore improve your advertising revenue.
It might make us more thoughtful, but there's a lot of Australian public that takes it flat.
Don't put it politely.
It isn't educated
Cool.
enough.
Brings me back to chicken and the egg. Are they not educated because they, read the Herald Sun? Or did they start off being uneducated and the Herald Sun just exploited that? Given that so many people get their information about the criminal justice system from the Herald Sun, it has an important educative function. The answer might be if the Herald Sun educated them more, they would there be less educated and therefore respond to that information more positively. So in actual fact, it all comes back to whether or not the Herald Sun's editors are dickheads or not. Yeah. Maybe. It comes down to what you said before about people being really interested in it, which is why there's always a queue out the front of the Supreme Court to get into sentencing hearings, right? No, it's a joke. There's not. No one really wants to go and listen to the details. No one gives a shit, right? They want a nice, simple message presented to them in a way in which they consume it quickly and form a quick, easy judgment that they can use at the ballot box. So the other people, sorry, were you going to say something, Katie? The other people that have a massive incentive to sensationalize are opposition parties. So given that you can sell the message, tough on crime, in fewer words, in fewer seconds on television than the message, we want a sophisticated rehabilitative policy that prioritizes long-term protection of the community and the rights of the defendant and victim. Which one are you going to put in your 30-second ad? Like, which one's going to be your soundbite? As an opposition party, you have an incentive to destabilize and manipulate the perception of the criminal justice system because the other side's just going to do it to you, and it's a vicious cycle that an opposition party can always do it because it's cheap and easy, right? Doesn't take a lot of sophistication, intelligence, research, polling. You always know people are going to hate criminals. You always know that people like doing bad things to people they hate, and therefore you have done your market research right there. There's your story. All right, what else is here? it's good news, I guess, if you know Ari and us in general, that the percentage of people who want harsher sentences is decreasing. That could be a useful statistic in debate if you want to point to the fact that with time and with education and with better communication and technology, people actually want it less and less. The other statistic worth noting is that the people who have contact with the justice system, or people who have confidence in it, either way, so that is respondents who had been around the criminal justice system in the past 12 months, or who admitted to having confidence in its ability to deal with these crimes, didn't want harsher sentences nearly as much as the people who had it. So that probably explains why there is a decreasing number of people who want harsher sentences. Okay. So, people were making jokes about my ability to speak off slides with only a heading. So, fear. I wanted to finish on this because it's important to note that people think that there is much more crime than there actually is. They're overwhelmingly scared of being the victim of crime when they actually have a minuscule risk of that exposure. Did anyone notice when The Age ran in the lead up to the last state election, big front page headlines with pictures and graphs that said crime is down? Anyone notice that? It just slipped through in the debate when The Age ran on its front page, crime is going down. Because everyone just lives in this world where they're ignoring that fact. And they just think that the world is getting worse. And that they're likely to be, the victim of crime around the corner. Which begs the question, what causes more harm in our society? Actual crimes or the fear of them? No doubt for people who experience those crimes, it really sucks. Because they either get beaten up or they get murdered, and that would really suck. But the direct consequences of crime are very narrowly distributed. So they exist to a very small number of people. It's worth noting that those people are often poor, young, black, and mentally disabled. The same people that we commonly assume commit a lot of our crime, which perhaps begs a question. But the point is that the number of people scared of crime is much, much wider. And even if that fear doesn't manifest itself in a broken leg, it is going to dramatically affect the comfort with which you go about living your life, your perception of how your society is, and will almost certainly define how you respond to criminal justice political debates, and therefore inform your likelihood of making a sensible, rational decision about a way to make yourself safer. Yep?
Prime example being violence in Conway, and how everyone's terrified of crime, so therefore they go out and buy guns.
Yeah. Although the one sort of caveat I want to put on what the point I was just making then is that even if you become highly engaged with the criminal justice system, even if you think it through, you're still going to get back to that inescapable clash between short-term protection and long-term protection, between fairness and reducing crime, and between those competing philosophies about whose perspective matters. So it's all good and fun for me to get up here and, brag on the Herald Sun, but even if their job was done perfectly, that doesn't resolve this debate. And you can't win a debate just by saying idiots are the ones making the decisions now, and if we educate them more, the debate will be over. Don't run away from those competing philosophical clashes, and that harsher sentences sometimes are in the community's best interests. And sometimes we have to prioritize short-term protection, and that is a legitimate philosophical position to hold. And that it is legitimate for average citizens to have their perspective indwelled upon a democratic system of doling out justice in their community. And it is legitimate, conversely, for people to expect those decisions to be made with the most accurate representation of that information. I don't know how long I've got, but I'm happy to answer any questions.